Hi viewers, welcome to another brief documentary from at Newsworthy Publications. My name is Ben Gray. I'm a citizen journalist living in Bristol, where I've lived for the last 20 years, dedicated to exposing egregious corruption, collusion in child abuse, among other things, amongst the judiciary, the High Court and Crown Court judiciary, the local CPS, and uh, further afield in terms of the Avon Somerset Constabulary and various of the so-called mainstream media. This brief documentary centres around a charge of criminal damage, which I was charged with in February of this year, 2025. Um, and It was supposed to go for trial last week. I'm making this documentary on the 19th of August 25, and it was supposed to have gone to trial on Friday. And the Westminster Magistrates Court, that is in charge of listing these matters and notifying me and so forth, didn't notify me that the trial had been adjourned to the 14th or the 15th of January 2000. I think it's the 14th of January 2026. And so I was effectively falsely imprisoned by the conduct of the Westminster Magistrates Court, and obviously that's for a different documentary. But the issue is that the court is also colluding in denying me my right to legal representation. I'm entitled to representation now that I've been charged with an offence that's set out clearly under Article 6.3c of the Human Rights Act 1998. And I can prove that I'm being denied representation, that I'm not being represented. It is not a question of my choosing not to choosing to represent myself. It's a question of firms collectively refusing to act for me, which the Westminster Magistrates Court judges, including Tan Ikram, who's heard submissions in this case, to refuse to address and engage me in the issue of my right to representation. This means that, well, added to this, the court has also imposed what's called a Section 36 court appointed lawyer. So I think it's under the Youth Justice and Criminal Evidence Act 1999. The court has the power to force the defendant or the accused to um, question certain witnesses through a solicitor. Obviously, this is expensive because the solicitor has to be appointed to ask the questions and supposedly take instructions from the defendant. And in this case, they've appointed a gentleman called, I say gentleman, they've appointed a solicitor by the name of Stuart Harris. Now, Stuart Harris is from H.P. Gower solicitors centred in Marylebone Road or Old Marylebone Road, central London. And as far as I understand it, H.P. Gower and Mr. Harris himself do legal aid. So this theoretically would address the question of my being denied representation to date, because no firm has agreed to, because as I say, I've had problems getting representation. So I've raised this with Mr. Gower, and I've also pointed out that as you can see from my other documentaries, to those that are interested, that I've got evidence that there is glaring evidence of child abuse, including paedophilia, within the various issues in my defence case. I pointed out, and I'll read the letter in a moment, but I pointed out that, for instance, um, Lord Justice Adrian Fulford, who has denied me leave to appeal in a case in 2021, has admitted and even apologised for having connections to paedophile Tom O'Carroll, who during the 1970s, because he was affiliated with a gay rights campaign group that Adrian Fulford was leading, and these two were therefore strongly connected, even though at the time Adrian Fulford was well aware that Tom O'Carroll, who was the leader of an organisation called Paedophile Information Exchange, which sought to make the bring the age of consent down to the age of 10, and to have the free flow of paedophilic images exchanged between adults. This was the central aim of PI, Paedophile Information Exchange. And Adrian Fulford, at the time, I think a barrister, was well aware of the objectives of the paedophile information exchange. And as I say, he had to apologise for his connections. And if you go to my documentary "Barbarians at the Gate" Part 3, I provide evidence surrounding in more detail the fact that the Judge Adrian Fulford has had to apologise and admitted to his connections to Tom O'Carroll and to Pi. That's just one example. That I've got two examples within the my defence case that individuals have thrown. I've been subject to armed attacks in public areas. In one case, a supermarket in 2008, February 2008, and in another example in 2000 in July 2018. And both these occasions, when missiles were thrown at me, they missed me, but and also narrowly missed hitting or seriously injuring nearby children, which again is evidence of child abuse because effectively children are being permitted with a collusion of the local police and various judges, such as Judge Martin Picton, and again, Judge Adrian Fulford, because he's been aware of this evidence, and Judge William Davis. All of these judges and more have been aware of this evidence that police are colluding in armed attacks that are against me, but also involving children as potential targets of these attacks. So that's more evidence of child abuse. And as I say, I'll read the letter out in a moment. But I raised all this with Mr. Harris. I pointed out that I'm unable to get legal representation. His firm does his firm does legal aid, so there's absolutely no issue with him representing me as a legal aid solicitor rather than as the court-appointed solicitor. So that would cover the issue of the fact that I'm unable to get representation and address my human rights, my human right to representation, because I've been charged with an offence and face potential custody. And of course, secondary, I've also pointed out the connections, the evidence that I have that there is evidence of judges as well as police and members of the CPS colluding in child abuse in terms of armed attacks against children, and Judge Adrian Fulford's connections to close connections to a paedophile information exchange. I'll read out the letter in a moment, and I'll read out Mr. Harris's response. But in short, Mr. Harris has refused to represent me. He's refused to say why, even though he's well aware that I'm not represented, and I have a right to representation under the Human Rights Act. And he's again he's totally uninterested in the evidence that I have of child abuse connected to the judges and other members of the CPS and the police who are colluding in it, or indeed engaging in it in some cases. Um, so what I'll do is I'll read out the letter and Mr. Harris's response, and then of course um, I'll explain in very short terms why, if any explanation is necessary, which hopefully it wouldn't be, as to why I can go online and publish that Mr. Stuart Harris is, among other things, a corrupt child abuser of the first order. So this is an email that was sent from myself to Stuart Harris yesterday on the 18th of August 2008. And the heading is Stuart Harris, final notice re request for contact from yourself and evidence of police judicial collusion in child abuse in this case. Mr. Harris, this is now the fifth time I have contacted yourself re your appointment as court appointed solicitor, re my request for legal aided defence, representation, and conflict of interest issues. I accept that you might need some time to fully respond, but the matter is urgent and distressing for reasons that are obvious, brackets, including my being threatened with criminal violence by security staff and police liaison officers if I enter Westminster Magistrates Court and being repeatedly falsely imprisoned, bogus hearings listed by court staff. And I would have expected you to touch base and indicate when you might have a more substantial response to my urgent concerns. Your conduct now borders on harassment in its own right, and if I have not heard from you by the end of next week, I will be entitled to assume that you are just another corrupt CPS crony and refuse to engage with you further, but will certainly address your conduct in open court when the issue of your appointment becomes pertinent. Indeed, to indicate the seriousness of my position, I refer you to evidence of police, CPS, and judicial collusion in, among many other heinous offences, child abuse, in bold and underlined, of which the following are merely three examples of many. A. At page 3009 of the King's Bench bundle, see Dropbox link below, you will see a statement from an Inspector Power from A&SC PSD, that's Avon Somerset Constabulary Professional Standards Department, who admits that police were informed a missile had been thrown at me in Tesco in February 2008. This was a container, I allege, glass that narrowly missed myself and exploded near children and other bystanders. The anti-white racist Judge Davis, Lord Justice, imposed the draconian civil proceedings order banning my litigating any matter, not in spite, but clearly because of such evidence of child abuse, ergo my having to resort to causing damage to get such issues before the criminal court where they belong. B. At the bottom of page 19 of bundle marked EX1 attached, you will note that PSD investigator Richard Budd included a police statement from a member of staff at Montpellier Health Centre, where I caused the damage in Jan 25, who states in July 18 he witnessed a woman throw a fork at myself, again narrowly missing both myself and children walking nearby. C. I also refer you to attached BBC article re Lord Justice Fulford, retired, who was the judge who refused me leave to appeal against conviction and sentence for assault, emergency worker, etc., in November 22 at Gloucester Crown Court. My defence included self-defence against a homosexual assault, as I am alleging in this case, from officers and my being refused en masse legal representation. You will note that Lord Justice Fulford admits he was part of a gay rights campaign group affiliated, in quotation marks, with PI, Paedophile Information Exchange, and convicted child abuser Tom O'Carroll, yet simply continued on the bench and with his gay rights campaigning into the present, and has even sat on child abuse cases, close brackets. As I say, I could go on, but it is clear that the reason I am being assaulted and effectively kidnapped by the machinations of court staff and judges at Westminster Magistrates Court is because they are all de facto puppets of the all-powerful High Court judges and others involved in the matters raised above and in my defence statement. For the same reason, unless I hear from yourself shortly, I am entitled to assume you are also in the pocket of paedophile and child-abusing judges like Lord Justice Fulford, Lord Justice Davis, Judge Martin Picton et al., and would rather ingratiate yourself with them than represent someone attempting to expose them for the corrupt, treasonous child abusers they are. I give you the benefit of the doubt, that should have said, but it says I give you the benefit, but that should say of the doubt, by not suggesting you were aware of the above particulars prior to your engagement with this case, and were not aware that I came up to London last week on the false premise I would be facing trial for criminal damage as the City of London Magistrates Court, and have not contacted me to date because you are just another lazy, negligent, arrogant, legally aided shyster, grifter, and parasite, like every other solicitor I have had the misfortune of being involved with or reading about. Now that I have apprised you of the evidence in question, however, you have until the end of next week to indicate whether you are prepared to act as my defence solicitor and whether you have a conflict of interest re the barrister's chambers cited in my earlier emails. If, by the time indicated above, you have not provided a cogent basis for refusing to act for me or address my conflict issues I raise, I will not only have no further dealings with you, but will publish on my YouTube channel that you are a corrupt child abuser on the basis that, as suggested, you are playing hard to get and stonewalling my communications with me because you know which side your bread is buttered and would rather serve the interests of the likes of pedo Judge Fulford and anti-white child-abusing racist Judge Davis than justice. Yours faithfully, Ben Gray. So the following day, i.e. today, I received an email response from Stuart Harris, and he states as follows. Dear Mr. Gray, further to your emails, the first of which was sent on Friday, the 15th of August at 4:15 p.m., this firm will not be accepting your instructions. This firm has accepted an appointment from the court to cross-examine the civilian witness, which has a limited remit. The work undertaken will only be in relation to the cross-examination of this witness, Mr. Locke. You may be able to find a legal aid firm via the Law Society website who are prepared to accept your instructions. you will need to enter a postcode, so you may wish to use the postcode of the court NW1. Regards, Stuart Harris. Well, as you can see, he's totally uninterested, unconcerned about the allegations I have of child abuse. So that's the first point to notice. Secondly, you will notice that he doesn't explain why he's refusing to take on my case as a whole. He says this firm will not be accepting your instructions. That's not actually the case, because even if he's only going to question the witness, Mr. Locke, he has to, these are considered instructions, i.e. I instruct him what questions to ask Mr. Locke. So he's already lying. He has accepted instructions to take instructions from me, because he's agreed to take on my case when he was appointed as the court-appointed lawyer. So that's not accurate or even true. But in any event, he hasn't explained, he's got no interest in the fact that I'm being denied my Article 6 right to representation. The only reason he's been appointed as the court-appointed solicitor is because the court, together with all the firms I've contacted, are refusing to act for me as the court is colluding with all firms that I've contacted in denying me my basic statute right to representation. I have applied to the court to make an application that the case cannot continue because I'm being denied my statute right under Article 6.3c of the Human Rights Act, which isn't very confusing or complicated. It's very straightforward. It states clearly that anyone charged with a criminal offence is entitled either to have solicitors of their own choosing, or if they can't afford one, they have it will be paid. A solicitor will be paid by way of legal aid. It doesn't say that specifically, but that's what the upshot of that legislation is. So this solicitor, who's supposed to, his main concern is ensuring his clients, or indeed obtaining clients, to represent against charges. That is his only function. He's aware that I'm unrepresented. He's aware that I am entitled to legal aid. He's aware that the statute law states that I'm entitled to representation, and he's aware that the only reason he's been appointed as the court-appointed solicitor is because the court is already denying me representation, which would obviously include questioning of any witnesses, CPS witnesses, as part of their role if they were defending me against the charge as a whole. So the least he should have done is explain why he's refusing to act for me. It's not because the firm doesn't do legal aid, because they do, and it's not as if he wouldn't be given legal aid if I am entitled to it by law. So that's obviously the first point to note, and he's again totally uninterested. I've made it quite clear that I will publish, as I'm now doing, to the effect that he is a child abuser. He's colluding in child abuse. He's colluding in perverting justice, I would suggest, because he's conspiring to deny me representation and therefore effectively affect the outcome of the proceedings in this case in the CPS's favour. It's not as if I haven't provided him direct evidence. I've referred him to chapter and verse of the evidence I have of collusion in child abuse. There's no dispute, it can't be denied, that Judge Adrian Fulford has paedophile connections to Tom O'Carroll, that he worked alongside him. He was affiliated with him as a sister or brother organisation in the 70s when he was campaigning for his gay rights campaigns. Mr. Harris doesn't have a leg to stand on. Indeed, it's quite clear that because of the evidence that I have of child abuse, it's so complete and so unarguable that is why he's refusing to act for me as my solicitor against the charges generally.